Mr. President, the reason that this amendment is being debated right now is that the administration issued an order that's just unprecedented. Now, it's unprecedented because the mandate provisions of the health care bill are also unprecedented, but that's the reason we're debating this now. The administration brought this up. I'm still amazed by the fact that the administration wouldn't have excluded all of at least the faith-based institutions from their order. I mean, the Catholic hospitals, the Baptist universities, the Catholic schools of all kinds, the Christian schools of all kinds, the Muslim daycare center. Why wouldn't they have exempted these people? Now they say, well, we exempted the church itself, as if the work of the church or the character of the church or the faith distinctives of the church, the synagogue, the mosque, are only what happens inside that building. You know, there's a reason that we have so much of our health care, our social services provided by faith-based institutions, and one of the reasons is that those faith-based institutions want those institutions that they fund, they support, they encourage to reflect their faith principles. And what's wrong with that? There are really a couple of issues here. One is the separation in the president's mind from the work of the church or the synagogue or the mosque and the building itself. And it's impossible to separate those two things. Otherwise, you just have another Christian school that happens, another high school that has a chaplain. You don't have a Christian high school. Or you have another hospital that's run by the Sisters of Mercy. You don't have a Catholic hospital, because you've decided you're going to define the character of what that hospital stands for and what they provide. Now, the administration recently took a Lutheran school to court. The EEOC took a Lutheran school to court and asserted that school didn't have any special constitutional protections as to how they hired people. And you could have heard all these same kinds of arguments. Well, they'll discriminate against people. They won't hire people that otherwise should be hired. They won't make accessibility to the handicapped. They won't do. You hear all of that sort of thing, none of which would have been true. And the Supreme Court voted 9-0 that the administration was wrong. And you can try all you want to separate these two issues, but they don't separate. They're both fundamental First Amendment issues. Let's talk about some of the things I've heard here this morning. My good friend Senator Bennett from Colorado said if this amendment passed, 362,000 Colorado women would lose their current their current health care services. Now, why would that be the case at all? This amendment does nothing to modify state or federal laws that are now in effect. If you've got those services now, there is nothing in this amendment that would change the world that we live in right now. People have the same protection today to exert their religious views in their health care policies that they provide as an employer that they would have if this amendment passed. They have those protections now. They would not lose those rights. It doesn't modify any state or federal law, and there are plenty of federal laws. There's a federal law on pregnancy discrimination that says pregnancy-related benefits cannot be limited to married employees. Now, that law doesn't go away if this amendment passes. State laws that require things to be in health care policies, if you have one, don't go away if this amendment passes. It only amends the new mandate provisions of Title I of the new health care law, the health care law that has received so much controversial attention for good reason, and this is one of those reasons. Supplying the respect for religious beliefs and moral convictions is already part of the federal health programs of all kinds. It just doesn't happen to be in the new law. There is no health care law since 1973 that doesn't have these provisions in this bill that are part of the law. The law is there now, Mr. President, and the world doesn't change. No Colorado woman will lose any health care benefits they have today if this amendment passes. No New Jersey woman will lose any benefits they have today if this amendment passes. Regarding any health care service that people may be worried about, we ask one question: are people allowed to exclude this service from their health care benefit under current state or federal law? And if they're not allowed to exclude it under current state or federal law, they wouldn't be allowed to exclude it if this amendment would pass. If they're not allowed to exclude it, they're still not allowed to exclude it under this amendment. And if they are allowed to exclude such service, why haven't the critics been protesting before? This amendment doesn't change anything in the law today. So why haven't we heard these speeches before about how the law doesn't protect employers from deciding not to offer this or not to offer that? In fact, this makes it much more difficult to exclude services than it is now. Much more difficult to exclude services than it is now. And in fact, it allows for an actuarial equivalent to have to be added to a policy if you take something away. Now that means there's no financial reason. There's no financial reason to exclude a service. Because if you exclude a service because you believe it's the wrong thing, the Secretary of Health and Human Services has the power to say, you have to come back and include a new service that we didn't require of equal value. Now, I assume everybody on the other side of this debate would think that employers must be motivated to exclude these services if they're not legitimate religious belief and moral conviction, that they must exclude them because they'd save some money. Well, we don't allow them to save money. So there's no reason. The Secretary of Health and Human Services can say, okay, you're going to exclude that, but you have to include something we didn't require of equal value. That means something that's going to be equally used. That means something that's going to be equally costly to the employer. So why would the employer do that? I mean, why aren't we hearing all these stories now about how employers are not, why did the 200,000 women that have these health services today, I think it's 20 million, why do they have those services? There's nothing in the law that requires it. This law doesn't change the laws today. Now, from the point of view of having a political discussion instead of a discussion about what the amendment does or why it's consistent with what we've always done, I think the other side's done a great job of that. But consistently, we have protected this principle of First Amendment freedoms. In fact, in 1994, in the bill that Mrs. Clinton, the First Lady at the time, worked so hard for, that was introduced here by Senator Moynihan, here's what it said. Nothing in, and this was a bill that also would require people to provide insurance. You know, we don't have much about insurance because we haven't required people to provide it before. There's some federal health benefits about insurance I may talk about in a minute that also are protected. But this was a bill that required people to provide insurance. And Senator Moynihan said in his bill in 1994, less than 20 years ago, nothing in this title shall be construed to prevent any employer from contributing to the purchase of a standard benefits package which excludes coverage for abortion and other services if the employer objects to such service on the basis of religious belief or moral conviction. Now, the most amazing thing about this whole debate to me is that in 20 years, this has gone from language that would be in what was considered the most progressive, liberal health care bill that had ever been offered by one of the most respected senators by Americans of all political philosophies, but most agreed with by Americans of a more liberal political philosophy, that he would just put that in the bill. And I've asked, is there any indication in the debate on that bill that this was a big item? And the answer I hear is no, it wasn't a big item because it was part of who we are. It was part of what we'd been as a nation. It was part of protecting the First Amendment. And this amendment does not mention any procedure because I don't know what kind of, and nobody knows what things might be in some future date religious to somebody's, offensive to somebody's religious beliefs. But you have no financial reason to not provide a service. So the only reason you'd really have under this amendment would be a true moral objection. And I had some immediate initial hesitation myself. It's okay, I understand the faith-based institutions. I used to be the president of a Christian university, and so I understand why it's important that those institutions keep their faith-based distinctives. But what about other employers? And frankly, I didn't have to think about that very long to realize if you are of a faith that believes that something is absolutely wrong, as an employer, why would you want to pay for that? You believe this is a wrong thing to do. Why would you want to pay for that? And the language of equivalency in this bill means if you choose not to pay for that, the secretary can say, okay, come up with something else that would be equally used and equally valuable that you would pay for. So there's no financial reason not to do it. The only reason not to do it is you truly believe it's a wrong thing to do. Now, surely every person in the Senate has at least one thing that because of religious reasons they believe is wrong to do. Do you want to be forced by the government to be a participant in that wrong thing? The things we're talking about here today, in my particular faith, I'm not opposed to all these things that the president said he would require. But that doesn't mean I should be any less concerned about people who legitimately, week after week at their place of worship, express this to be something that you should not participate in. Now, if the congregants want to go on their own and figure out how to participate, that's one thing. If they want to go on their own and provide insurance to their employees that include these things that they just heard at church are wrong to do, that's another thing. But if they want to say, look, I'm not going to do that, but under the new mandate, we don't do anything here that eliminates the mandate. There's still a mandate. Under the new mandate, I'm not going to do that, but I'm going to have to add something to the policy, to the mandate, that would be of equal financial value, of equivalent value. So the only reason to object, Mr. President, is you believe it's wrong. And that's what the First Amendment is all about. That's why consistently through employment law we've protected, even though the administration lost a 9-0 case trying to interpret that the same way they want to interpret this. But no, the government knows best, and if you're allowed to, you'll abuse the hiring situation. Now they say if you're allowed to, you'll abuse the health care providing situation. I think we've taken away the financial incentive to do that. I believe what this does is protect First Amendment rights. The first freedom in the founding documents is freedom of religion. And we have protected it over and over and over again. Every member of this Senate who's been here in any recent time, except the very newest members, have voted for bills that had this language in them, whether it was the Clinton administration, whether it was the Moynihan proposal, whether it was the Patient's Bill of Rights, or the Religious Freedom Law. It was all there. Now, I think it's to come up with all these cases that they wouldn't treat prenatal care or might not treat cancer. Why would they not do that? Why would they not do that? If they don't treat that, they have to pay for something else of equal value. Look at the very last provision of this amendment. So there's no financial reason not to do this. The only reason is that you believe it is against your religious views. And the phrase we use in this bill is exactly the phrase that Senator Moynihan used. It's exactly the phrase that Frank Church used. It's exactly the phrase that people on the floor at this moment voted for when they said we don't want people to have to participate in capital punishment or prosecuting crimes where capital punishment is a possibility because of religious belief or moral conviction. It was good enough for everything up until now, including this principle, until we get to 2012, and suddenly we have all these reasons that people can't make faith decisions that relate to providing health care to employees. And I disagree with that. I think the First Amendment protects that. I believe if and when, and if this rule goes forward, it will go to the Supreme Court, it'll be something close to that 9-0 decision on hiring rights. There is no difference in the principle here. And again, I'd say look at the last section of this bill if you believe that employers are going to do this to save money. And otherwise, what motivation do they have besides the moral conviction and religious belief that is protected by the First Amendment? And I hope my colleagues will read this bill carefully, will understand that there's no protection given, that no protection currently in the law is taken away by this bill. If you have a right now, you would still have it if this amendment passed. And to argue otherwise just denies the facts of both people who have coverage today and 220 plus years of constitutional protections in the country. Read the bill. It may not change any minds today, but this issue will not go away unless the administration decides to take it away by giving people of faith these First Amendment protections.